Welcome, everybody. Thank you so much for joining us today for the Wills and Estates Planning in Agribusiness webinar presented by the Queensland Farmers Federation Farm Business Resilience Program. Today's webinar is jointly funded by the Australian Government's Future Drought Fund and the Queensland Government's Drought and Climate Adaptation Program. My name's Bec Carl. Joining me today, we have Kylie Wilson, Partner, Corporate and Commercial at Sparke Helmore Lawyers. We also have a few participants joining us from our member organisations and our board. It's wonderful to have you with us. My colleague, Julia Jergs, is also joining us today to ensure we don't miss any questions you might have for Kylie. With that in mind, we do have quite a few people registered and we will try to get to your questions along the way. We have disabled the chat function, but please use the Q&A function for any questions you might have. You can also upvote anybody else's question if you think it's a particularly great one. Today's session will be recorded and the slides circulated after the session. If we don't manage to get to your question today, we will follow up afterwards to make sure you get a chance to have your question answered. We have also enabled the option to post in the Q&A anonymously. However, if you do this, please just note that we won't be able to follow up with you afterwards if we don't get to your question. So without further ado, I'd like to introduce our presenter today, although she needs little introduction. Kylie is a recognised succession planning law expert, listed in the Best Lawyers Australia 21 to 24 editions of Wealth Management Succession Planning Practice. She's an accredited self-managed super fund specialist advisor and an accredited family business advisor. She's worked with family businesses for over 20 years and has many business clients in their third and fourth generation. Ensuring businesses can remain viable without the risk of litigation devolving business assets is one of her key areas of specialty. Kylie also works closely with advisors to prepare compliant solutions for a range of clients with complex structures and as well as rural and business clients and families with diverse dynamics. QFF's privileged to have Kylie and Sparke Helmore Lawyers as a corporate partner. Thanks so much for joining us, Kylie. Over to you.
Thanks, Bec. Great to be here, and thanks everyone for joining for what is a fairly important topic. Now, the plan for today is generally to discuss wills and enduring documents. We'll also do a little bit of estate administration, and we will talk through a number of things. As Bec said, feel free to ask questions. I can't actually see the questions, but Bec will let me know when we have questions and I can talk through all of that. Some of this area does deal with a little bit of litigation. For the purpose of today, I've focused on Queensland Queensland legislation. Now, from that perspective, most of this, particularly with enduring powers of attorneys and wills, is state-based. If you have questions about things from other states, that's fine, we can cover that. And otherwise, you can contact me afterwards. We can go through that if something specific comes up. So today, wills, some of the things that you should be thinking about. Now, this will be focused a little bit on things that we see go wrong if they're not dealt with in wills, just to highlight some of the main issues. Structures that affect your estate planning. Now, in particular, if you have a number of different types of entities, if these aren't reviewed in the context of doing your estate planning, it can actually completely undermine some of the terms in your wills. And also with enduring documents, they can impact those structures. So we'll have a bit of a look at those issues. Capacity in enduring documents. Capacity is an issue we're seeing more and more problems with. As we age, medical science is keeping up with us physically, but maybe not so much with our brain. So those stages of dementia in particular, and when capacity occurs, just highlights the importance of enduring documents, and we'll look at a couple of issues there. Probate when it's required, because I get a lot of questions about is probate required or is it not, and we'll look at what actually impacts that. And intestacy, this is to deal with if you don't have a will or you're talking to someone else who doesn't have a will, what the problems might be. Not a good problem to have, and we'll look at exactly what happens in that scenario. So from the perspective of going to your local solicitor or going to a solicitor and looking at your will, one of the first things that you need to do even before you get there, and it sounds a bit silly, but it actually is a relevant point, know what your estate is. Because, for example, things held jointly, so bank accounts, property held as joint tenants, for the most part, the rule of survivorship applies there. So in the first instance, we commonly see this between husband and wife owning property. That isn't dealt with by your will. It will automatically go to the survivor, so it'll be dealt with in the survivor's will. And you need to consider those things when you're thinking about your wills and estate planning. Amounts that are owed to you, obviously that's payable to your estate. We'll spend a little bit of time looking at one thing that's often missed is amounts owing by the trustee of a discretionary trust. These often arise in financials, and that's actually payable out to the relevant beneficiary that's owed to by the trustee of a trust. Superannuation death benefits can cause a bit of confusion. They are part of your estate if they're directed to your legal personal representative. Superannuation itself doesn't automatically form part of your estate. A partnership interest that's held by you personally, we'll have a little bit of a look at partnerships because they're very common in agriculture, and there are a couple of potential problems with partnerships if they're not dealt with prior to you getting the point of the will coming into effect. And then other assets in your personal name. Obviously motor vehicles, if you've got plant and equipment in your personal name, listed shares in your personal name, etc. So understanding who owns what, this will be a little table that will be beneficial to look at and work through your assets as you're thinking about these things. So who owns the asset and where does it go? As we talked about, if it's a personal asset and it's owned as tenants in common is separate divisible shares, so the relevant share will go to your estate. But if it's owned as joint tenants, it'll go to the survivor. Superannuation death benefits with a binding nomination, that will depend on what the binding nomination says if it's valid. So it's important with super to make sure if you have a nomination that is actually a valid nomination, because there's a few issues that can arise in that context. If you don't have a binding death benefit nomination, the trustee of the fund, whether it's a public fund or a self-managed superannuation fund, will retain discretion about where it goes. And so you need to think about, particularly with public funds, what are the rules that they have that dictate where your benefit goes, because it may not actually be what you intend. So you need to have a look at that and think about that. If it's a private company or a unit trust, you need to understand the ownership of your shares. So a company, for example, if you own the shares in your individual names, those shares are actually dealt with as part of your estate. So you need to actually know, if you have a company, what's the shareholding and how is it dealt with. If you're a sole trader, that's in your personal name. So that will be part of your estate. Life insurance, where the individual is the policy owner, it's the individual. Company shares, we've dealt with who owns them individually. If it's a third party with the life insurance, the third party actually owns that policy. One we'll look at a case study on where some issues arose in particular, but unpaid present entitlements or loans payable to an individual in trust financials, mainly discretionary trust financials, that is payable to the individual that they're owed to or to the estate on call. These things often arise in financial statements for trusts, and often they're done for tax reasons over time. What most people, or a lot of people, don't realise is that at law, those payments are actually able to be called upon to be paid. So in an estate, for example, where the executor has a duty to call in assets of the estate, the executor is under a duty to call for those amounts to be paid to the estate out of a discretionary trust, and that might not be what you intend to happen with the assets in that trust. Interest in a partnership. If there isn't a partnership agreement that says otherwise, that your share of the partnership will be an estate asset. Family discretionary trusts. So most trusts, New South Wales is a little bit different if there's a national estate application, but generally your trust assets are outside of the estate. You need to look at what the trust deed says. So who's the appointer or guardian or principal of that trust in the trust deed, because that's actually where control of those assets will sit. Often trust deeds will say if an appointer whose name passes away, it goes to the legal personal representative. that becomes your executor to control that trust, but that doesn't mean those assets are dealt with by the terms of your will. And personal assets subject to a put and call option or buy sell. We see this in family farms now and then where there's an option to buy. Those are enforceable against the estate, so you need to look at those agreements if they're in place. So looking at your first point of call when drafting a will, one of the first things you have to think about is who is your executor. We always say, ideally, unless it's some sort of entity or a law firm, think about who then is your fallback executor, because if you are not survived by your executor, you need to have someone else stepping in. This particular case, Sam appoints what is commonly done, his wife, and then if his wife can't act, he appoints his 2 children to act as executor. Doesn't update his will for quite some time. On his death, though, his wife is in aged care with dementia and has no capacity. So his children are appointed as fallbacks. And then we have this was an actual case a couple of years ago. Sam's daughter has a bipolar disorder. Sam's son has a gambling addiction. Sam's daughter has an apprehended violence order against Sam's son. Do we actually think that they're able to administer the estate together, acting jointly? So you do need to think if you're appointing children, and the answer to that obviously is no. If you are appointing children as fallback executors these days, it's not necessarily an honour to be appointed, it's an administrative role and you have duties. Are your executors actually able to comply with their duties? Particularly if you've got more than one appointed, are they able to do that acting jointly? Because if they're not, you shouldn't be appointing them, and you need to think about different options as far as who should be appointed in that situation. So then otherwise with wills, thinking about how you're going to actually draft the will, what's going to be in there, be conscious with specific bequests. These can often create problems because what if you don't own the asset at that point in time? That bequest is going to fail. Is there a debt attached to the asset? Is that supposed to be going with the asset when it's passed to someone specifically? So if it's a property with debt and a mortgage over it, is that actually supposed to be staying with the beneficiary who's receiving the asset? Because if it's not, that debt has to be paid out by your executor before that bequest is made to the beneficiary. And that can impact the residue of your estate at that point. So you need to think fairly carefully about specific bequests if you're putting them in there. When you're thinking about the balance of your estate, are you putting it between people? If you're doing that, be very careful about cash amounts left to people. We've had one, and we see this fairly commonly, where it was smaller estate, someone had left specific bequests of $50,000 between multiple grandchildren and children-in-law, and one of the main assets was property. And the problem was there's not enough liquidity to pay out those bequests and still keep the property, which is what the children actually wanted to do. So you need to be a little bit careful when you're thinking about that type of thing. If your rest of your estate you're leaving between people, we prefer to see percentages because then we're not dictated by what sort of amounts are in there. So think about those type of practicalities when you're thinking about that. Should testamentary trust be considered? We'll have a little bit of a look at this because testamentary trusts are something that can be set up by your will that might be very beneficial from an asset protection perspective or for tax purposes. What's the overall plan when you're thinking about your will and estate planning? What might be emotive issues that can arise? What might be a failure of communication between the next generation, for example, that might cause issues that you might want to be thinking about when you're working through your estate planning? So this was one that we had a number of years ago, understanding what's in the estate, how things are going to be passed. Dad had done a very good job of building assets over time. One son was involved with the dairy, had put some money in at one point when they sold a smaller dairy and bought a larger one. Son thought that that meant they were in partnership together. It was actually acquired in a trust. And unfortunately, in that scenario, what son thought was not accurate. And his actual interest in the dairy was not able to be determined at 50%. It was a different issue because it was owned by a trust. And then we have other children off farm with assets intended to go via the will to those children. And your problem that you can have when there's emotive issues in case, although son in this case was receiving a much higher asset, a lot of emotion and potential dispute that arose took a fair bit of work to unwind and resolve. So understanding what sits in your estate that you're dealing with, what sits outside of your estate, what the long-term plan might be, particularly if you've got structures in place and things you need to consider in your will, is your will actually catering for that properly? And that's something that needs to be worked through and identified correctly for your estate planning to actually be done properly and limit the risk of dispute. So looking at testamentary trusts, I want to touch on this just a little bit because sometimes there's a bit of misunderstanding about what testamentary trusts actually are. So that's a trust established by the terms of your will. We often look at these where there's high value assets and we're wanting to provide for the next generation in testamentary trusts where they can look at supporting, particularly if they've got grandchildren under 18, because beneficiaries under 18 in testamentary trusts receive the adult tax-free threshold. So $18,200 per child per year tax-free. So that's worth considering if we're looking at distributing fairly large amounts down to adult children in particular, where they either have or are likely to have young children that they need to pay things for over time. They can look at doing that fairly tax effectively out of a testamentary trust. They're very flexible, but it's important that they are drafted well because often we will see wills with particular trust terms put in the will without a trust deed in the will. These, once established, are actually trusts that go for quite some period of time. Depending on which state you're in, that's moving a little bit, but at the moment, generally at least 80 years. And if you're only got a few terms, that can create some unexpected problems down the track if they need to actually amend the trust terms or change a few things. There might not be the right provisions in the will for them to do that. So it is important that they're drafted well, because once they're set up, they can go for more than one generation. So some of the things that are looked at when we're looking at setting up testamentary trusts, it's considerations around what the assets are and what some exposures might be. So often if we have adult children, we're looking at everything going with the surviving spouse. We generally look at testamentary trusts separate for each child, because what's often not considered when these trusts are established and go long term, if you have more than one adult child in a trust, let's say in this case we had 3 adult children in the same trust, you can end up with problems with how the trust is managed over time, because their interests might be different. They might have more, one might have more children under 18 than another. Someone's getting more tax benefits than somebody else, that type of thing. So we'd normally look at making sure there are separate trusts between adult children, because they'll have their own separate family groups if we're looking at setting up that type of testamentary trust. Testamentary trusts also have a major advantage of asset protection, because they're set up via the will and the assets are distributed into the trust, but at that point they're owned by the trustee of the trust on trust for the beneficiaries, and they're fairly good asset protection if any of the beneficiaries are sued at a later point for any reason. So if we have a situation, obviously with husband and wife, for example, and they have their own asset protection issues where they might be have a claim against them at some point in time, we'll often look at the spouse actually taking control of the testamentary trusts rather than taking it in their own name, where it might be able to be accessed by creditors. So these are some of the things when you're looking at trusts to be worked through. And then if we have a situation where we have children, young children in particular, and we want the spouse to be able to get the benefit of distributing and paying for things for children if something happens to one of them, we might look at one trust that the spouse controls for the benefit of the spouse and the children. So looking at these examples, the main thing to keep in mind is that when you're doing wills and estate planning, these are generally drafted for your circumstances at the time. They should be reviewed at least every 5 years or earlier if circumstances change. Now, that doesn't mean change it, because it may still suit your circumstances, but it does mean actually pull out the documents every 5 years at least as I say, or earlier if circumstances change, and see if they actually suit your situation. Because it may be that things have changed significantly, children get older, there's other things you might need to think about in your estate planning. So that review is important because from an estate administration perspective, trying to deal with a will that was drafted some 30 years prior that doesn't actually cater for things properly is unfortunate for the family. So it's important to review these things regularly and think about whether your terms actually work for what you have. And keeping in mind with testamentary trusts, they are terms in a will. So a couple of important things to remember, they are not established until the will comes into operation. I will often have people say to me, they've set up a testamentary trust for their children and they think that that trust actually exists. It doesn't exist until they're not here anymore. It is a document in a will, so not actually set up until the will comes into operation. They do protect against later third-party claims against assets. They don't these days necessarily protect against divorce. So if you're setting up a testamentary trust, you need to have advice around what sort of things might be in place if you're concerned about that being a problem down the track. They will not automatically protect against divorce because the family court will take the assets of the trust into account, keeping in mind that's once they're set up at a later point when the will's in effect, not when they're just drafted in the will. And they do not protect against family provision applications because they are in a will, and anything in the will as part of the estate will be available to for an application if someone thinks that they should have further provision than what they've been provided for in the estate. So when I talk about wills being drafted and considered properly and thinking about what assets you have, how they're going to be spread, who needs to be looked after, who needs to be provided for, what considerations need to be in place. Simple wills are not always the answer. So this was a case I had a few years ago in New South Wales where Dad had passed away. He had bought his version of succession planning, had been buying rural properties with his 3 kids over the years and owning them with the kids as tenants in common. Now, when Dad was in hospital, not very well, question of capacity was a strong one. His will was redrafted so that all 3 children, to receive the properties that they had a half share in already, had to pay out the debts on everything. They also had to pay Mum, who at this stage was in her late 60s, an annuity of $30,000 a year each. And if any of the children failed to make any of those payments, all their gifts failed. So even if 2 of the children made the payments, if one of them didn't, they all didn't receive their properties. Let's just say that was not an ideal will. So what happened in that one? There were 4 family provision applications. The problem we had with that was in that particular scenario, the youngest child got the smallest property. There was the potential over time with Mum's annuity to actually end up with a negative bequest. So there were all sorts of complications in there. All 3 children claimed, Mum claimed. We had issues of capacity, rectification and construction in the will. The cost could have exceeded over $3 million. It managed to get it settled at mediation. It wasn't easy, but it got settled at mediation. But keep in mind, in that type of scenario where there are problems in the will, some things haven't been considered when it's been drafted, some complexities have been drafted in that actually don't practically work, would have had 5 sets of lawyers because you have the estate and each of the beneficiaries having to be separately represented, forensic accountants, valuers, and no one comes out of the other side of that particularly happy with each other, even if it is settled at mediation. So thinking about these type of things, particularly with wills, and putting some time and effort into exactly what you're looking at drafting and what might happen in the long term as far as that being administered is really important when you're going through the estate planning process. So keeping in mind that estate planning, as I talked about, is not necessarily just what you might think is in your estate. We need to also think about the structures that impact your estate planning and how that can create problems if they're not addressed. So predominantly the structures that will impact will be discretionary trusts, companies, mainly with the shareholding, partnerships, and self-managed superannuation. And we'll look at each of those briefly as far as the specific things that need to be considered with them. So from the perspective of these structures and where we commonly see areas of dispute, which is what you're trying to avoid when you're going through this process of the long-term planning for the financial future of your family. If it's a sole trader, the documents that they need are the will and enduring power of attorney. Where we see problems with those are a family provision application or a capacity dispute. Capacity disputes are on the rise, and I'll talk about enduring documents in a bit more detail, but they are very important, as important as the will. So partnerships, it depends on the partnership agreement. So for the most part, and particularly in Queensland and New South Wales, if there's no partnership agreement, a partnership automatically dissolves on death. Now, that might create some problems as far as what you're planning with the partnership assets. So you need to actually think about that, have a look at it and decide if you need partnership agreement. So if there's no agreement and it doesn't say otherwise, that partnership share, if it's owned by individuals as opposed to a partnership of structures, will be dealt with under the will. A company, relevant documents are a constitution and shareholders agreement. Number of disputes you can have in that space, and if the shares are owned personally, subject to your shareholders agreement, they'll normally be dealt with in the terms of the will. Discretionary trusts, you need to make sure you can actually, I'll talk about this a bit more in a minute, locate your trust deed. But relevant will be the trust deed, any variations to the trust deed. If trust deeds are varied, the variations are usually variations of the terms of the trust. They need to all be kept together because that becomes all of the terms of the trust deed. So we're starting to see more beneficiary claims in that space. Issues about the exercise of trustee discretion, keeping accounts, and family provision claims if there's loans owed out to individuals that are payable to the estate. So we'll have a look at that in a bit more detail. Unit trusts, look at the trust deed. Is there a unit holders agreement? Similar to companies, if units are held in individual names, they'll be dealt with in the estate and they can be subject to a family provision application. Self-managed superannuation. Trust deed is the be and end all for self-managed superannuation. So you need to actually understand what's in your deed and if it's up to date with where the law is, and over the next probably 12 months where the law is heading. Do you have a trust deed? Do you have a valid binding death benefit nomination? Your binding death benefit nomination in superannuation must match the terms of your trust deed. If someone's drafted one without reading the deed, it may not be valid if it doesn't match the terms. So issues there are obviously compliance with superannuation law, exercise of trustee discretion where we can see challenges against death benefit payments, and family provision if death benefits are paid to the estate. So general control issues that need to be considered with these entities as well. Who controls what? That's just a little table that'll help you work through what you might have if you have these structures, and what impact would happen if the worst happens, who's actually going to control things. Real property, personal property, it's the estate, or if you don't have capacity, your enduring power of attorney. And then as we go through those other bits and pieces, constant theme is if you have any trusts, know what's in your trust deed, who's going to control that. If you have a company, do you have a constitution, shareholders agreement, etc. So partnerships, I just want to touch on a little bit further because, as I say, we see them a lot, particularly in agriculture. I'm mentioning here the Queensland provision. It's also, there's a similar provision, different number, but much the same in New South Wales. But the Partnership Act will apply if you don't have a partnership agreement. Partnership Act in Queensland says dissolved by the death of any partner. That share goes to the estate. If you are particularly in partnership with other people as opposed to family members, you might need to think about provisions for insurance funding if something happens to one of the partners, and there's an issue about what's going to happen at the business if that occurs. So this crops up from time to time, particularly where we have unrelated partners. This was a manufacturing business with two partners who had a standard partnership interest of 50% each. Harry had a wife and two children. William was divorced with three adult children. Unexpected occurrence, and William has a car accident. Harry still has his 50% of the partnership, but William's estate, where it's going to his three children, they have that percentage share of the partnership, and Harry's suddenly in business with William's children. And that becomes an issue that has to be resolved as far as what's going to happen with those partnership assets or the business that's in the partnership. So understanding what's in your partnership, who have you got in the partnership, particularly if they're individuals, what is the impact that occurs if something unexpected happens. In that particular case, the comparison is if there's a partnership agreement with put and call options, partnership agreement, and William had life insurance could be paid to William's three children via the estate, and Harry could exercise his option to acquire the partnership share for $1. Much easier resolution for Harry to be able to continue with the business, other than trying to resolve what's going to happen to the business with the three children, or we don't have that type of insurance funding option. So particularly if you are in any similar, if you're in a company situation with shareholders, looking at what agreements you actually have in place to deal with what might happen if something happens to someone that you're in business with. So a quick look at trusts. I'll focus mainly on discretionary trusts because largely they're the trusts that we see crop up across the board in family business, but particularly with families where they have assets that are intended to go long term, what we need to look at there. I'll touch briefly on unit trusts and a bit further on self-managed superannuation funds. So discretionary trusts, often called family trusts because generally it's the same family as beneficiaries. You do have to be very aware, particularly these days, of what is actually in your trust deed terms as far as beneficiaries and who's provided for. There's a particular off-the-shelf deed that I've seen a number of times now, regionally, particularly in New South Wales, where one of the classes of beneficiaries is just called general beneficiaries. And it includes not only the children of mum and dad, but every other relation right down to cousins. That's a problem if you've got large assets in there, and I'll look at a particular case where that arose, where those beneficiaries actually think they should have been considered. So know who your beneficiaries are. Beneficiaries are discretionary objects. In a discretionary trust, they don't have a fixed entitlement. There will normally be a corporate trustee or an individual trustee. If they're a corporate trustee, you will normally see the shares of the corporate trustee owned by the individuals who will normally be the first beneficiaries of the trust. And you need to think about, as far as the estate planning is concerned, how is that being impacted by the terms of the will? Trustee has duties that are important for the trustee to understand. So these family trusts have often been treated as personal assets. They aren't. They're held in a separate entity. There are a whole range of reasons you need to look after these and consider your duties when you're moving forward. Your trust deed will govern your discretionary trust, as will some trust law. Most discretionary trusts, if you look in your trust deeds, someone will be named an appointor, a principal, or a guardian. Occasionally that's the trustee, but normally that's one of the first beneficiaries when the trust was established. If something happens to that person, if you have a death event or a capacity event, you need to actually know what the trust deed terms say about who's going to step into that role, because the person who's named that is normally the person who can change the trustee. So your fundamental control of a discretionary trust is actually usually with your appointor, if that's the person named. You need to understand what happens if something goes wrong there, because the last thing you need is people disputing about who's actually going to be in control of that trust, particularly if there's significant assets in there. If you have no ability to appoint a trustee because we have appointors or potential appointors coming in who are arguing, for example, you're normally looking at a court application to resolve it. and that's not ideal. So understanding what's in your deed and what the terms say where something goes wrong, particularly with the appointor provisions from an estate planning perspective, is fairly important.
Kylie, just on that, I think you might have just answered that question, but we have our first question, which is, in a family trust, is it possible to have two appointers?
Yes, it is. And it's also possible in most family trusts to then say how those appointers can act, which is different to executors. So look at the terms of your deed. Most trust deeds that I see, if they've got two appointers named, they're often being appointed jointly. And as I said before, where you look at joint appointment, normally if you've got joint appointors in a trust deed, if one of them can't act, the other still can, but it is subject to the trust deed terms. So that's why it's really important with a discretionary trust that you know the terms, which means you have to be able to locate your deed. We're often dealing with lost trust deeds. It's really important, both the trust deeds and any variations you can actually locate. No more questions there, Beck?
Nope, that's it.
Okay, so we'll move on then to duties, mainly because this is an area where we're starting to see potential disputes with discretionary trusts, and where beneficiaries can actually bring an action to create problems in a trust are usually because a trustee has breached one or more of their trustee duties. This is by no means all of them. These are just the main ones where we can see problems. So a duty to carry out the terms of the trust, you are automatically going to be breaching your duties if you cannot locate your trustee, because if you can't know the terms of your trust and read the terms of your trust, you're not necessarily then complying with your duty to carry out the terms of the trust. Duty of care in the management of trust affairs, a duty to administer trust affairs impartially, looking after them for the beneficiaries. The one that's arising a bit in disputes, the duty to perform trusts honestly and in good faith for the benefit of the beneficiaries, and the duty to keep accounts. So keeping accounts properly with your trust, that's often a simple one where people can bring a claim to create a problem because accounts haven't been kept properly with the trust and with the trustee's duties. So this is a case from a number of years ago now, but it's a good one as an example of what can happen if a trust hasn't really been managed for the benefit of all the beneficiaries. So this was a trust that was established by mum and dad in 1970. It had assets in excess at the time of 23 million. Over a number of years, there'd been distributions made in varying ways. So income distributions and capital distributions to mum and dad and one of the children, or just to mum or just to dad or just to the child, or a combination of all. But in all that time, two other children who were also beneficiaries of the trust hadn't been considered by the trustee in making decisions about in each year how discretion would be exercised. So the two other children successfully argued that distributions were made without real and genuine consideration of the circumstances of the beneficiaries. And the consequence of that is the trustee was removed. So this isn't really necessarily like family provision applications where people will bring a claim because of the likelihood that they will get more or they will get something. But what will often happen here is that the court will feel that it has no choice but to appoint an independent trustee. And what you need to keep in mind, if an independent trustee is appointed, A, it's expensive, and B, what they're likely to do, because they don't necessarily want to manage this thing for another 50 years or whatever is in place as far as the vesting period of the trust is concerned, is they may wind it up and distribute it between the beneficiaries. And at that point, those children are probably going to receive something as beneficiaries under the trust, because someone independent will consider all of them when they're making those distributions. So fairly important these days to be thinking long and hard about what's in your trust deed terms and who your beneficiaries are, because if you aren't considering them, particularly in a closer group, that might create some problems over time. So the things to watch for in discretionary trusts, if you don't distribute yearly, if you don't make your resolutions, the ATO will tax you at the trustee level, which is the top marginal rate. So you need to make sure that you are resolving to distribute any income from your trust in every year. Loan accounts to beneficiaries can build up. I do harp on this a bit because we see it quite a lot as a problem. You need to know what your loan accounts are because at law, they're payable on call. So particularly if they're owed out to beneficiaries, often that's because, generic example, mum and dad put money in to buy an asset and the accounting program has called it a loan rather than a gift. That's actually payable back out to the estate. It might not be the intention, so that needs to be considered in the estate planning. Disputes can often arise over who owes who what and what the financials actually reflect. Can mean that the asset value is not actually sitting where you think it is. So if you think you have assets in a trust and it's separate, and particular if you want to leave control of that to one child and your estate assets to somebody else, if you have a loan that goes out to you, that value over here is going to end up over here. So you need to know what's sitting in those financials. It can have really unintended consequences. So knowing that and what's sitting in there, this is one from a few years ago. Very large primary production business that son had been running for probably 25 years. Pretty good at his job. He'd grown its turnover fivefold over that 25-year period. But dad still had the reins as far as the assets were concerned. Where we're certainly seeing some problems arise from this type of control perspective, Parkinson's with fairly early stages of dementia still had capacity, but not necessarily making the decisions he would normally make. Slight dispute between him and the son who have been conducting the business over how they're going to deal with a particular asset. Decides to consider the two younger sons, one of whom is a lawyer in London, the other is a stockbroker in New York. So it gets a little bit worse. What happens then if dad is the sole director of the corporate trustee of a discretionary trust? Sons had nothing to do with the financials. Dad has signed the financial statements and dealt with all the tax returns. Son's salary is allocated to his beneficiary account as a drawing in the financials of the trust. Now, a trust can't have drawings. Drawings in a trust is a loan. So Bill's loan account was pretty significant over that 25-year period. And what do you think his two lovely brothers did the minute they got control of that trust? They called for the $6 million. That was the loan sitting in Bill's account for his salary that had been paid over 25 years. And that one settled on the doorsteps of a 10-day trial in the Supreme Court. So knowing what's in your trust deeds, where control might pass, what might be a problem in those financials, literally just looking at your balance sheet in the liabilities, who's owed what out of your trust financials. It's a really important part of the overall estate planning and succession plan as you're looking at things.
Okay, Kylie, I'll just jump in. We've got one additional question.
Yep.
Is it possible for an appointer to remove a trustee? E.g., if a husband is the appointer and the wife a trustee and the marriage dissolves, can the trustee be removed and therefore cause further legal issues with any settlement?
Yes, it depends. Again, depends on the deed, but generally, on a general basis without seeing the deed, if someone's the appointer, the deed will normally say that they can remove the trustee and they can put someone else in place. From a family court perspective, though, the family court's actually going to consider who's done what in that trust and whether the assets are part of the matrimonial pool. If husband, for example, controls the trust and wife's the trustee, even if husband removes the wife, that those assets are going to be considered most likely to be part of the property pool. But certainly from the perspective of how the appointor provision normally works, it is the appointer who can change the trustee generally. But you need to read the terms of your deed. I do see some unusual ones from time to time that have something a bit unique in them, but normally it's your appointer who can say who the trustee is. So yes, normally your appointer can remove whoever's in place.
And one other one while we're on this topic,
Yep.
How do you manage loan repayments from the trust?
So it depends on exactly what you need to do with what the loan is. Obviously, if the trust owes the beneficiary funds, that, as I've said before, might be need paid out to the estate. You need to think about if that's where you want it to go. So sometimes we actually might want the loan account paid out to the estate because we're looking at testamentary trusts and we want more value in the testamentary trust because there's better tax outcomes for children under 18 there. But if we don't want it to go to the estate because we're concerned about a family provision application, you need to think about whether or not your will is actually forgiving any loans that might be owed to you by the trust. So that we can look at in the will. If you're talking about loans that are owed out to entities, it's a slightly different issue. You need to talk to your accountant because there can be commercial debt forgiveness issues with that. But from the perspective of a beneficiary who owes money, who is owed money by the trustee, the beneficiary can actually forgive those. If you're looking at how you're dealing with the loans over time because of different tax issues, you need to work through a longer term plan with your accountant because there can be tax issues if they're crystallised too quickly.
And I think you may have just answered this question so slightly too, but as an in-law, Bronwyn asks, am I liable for repaying my partner's acquired loan, aka salary or verbal rental agreement, to said family trust?
If you're actually the partner, you're not necessarily the person that owes the funds. But if you're looking at it from the perspective of, so your partner, if they owe money back to the trust, it depends on whether the trustee is going to call for it or not. And certainly, but if it's an individual loan, you individually need to be liable for it. You need to be really careful about what's happening in financials of a trust just for accounting purposes. There are often reasons for that to be done, but if you're concerned about any loans that are appearing, you should get legal advice about exactly how those work if you've got concerns about what might be called on and by whom. Any other questions there, Beck?
No, that's it. That's all we've got for now. Thanks.
So I'll just really quickly deal with unit trusts. They're not as common. They still pop up from time to time. Often they're used to acquire property where you have unrelated parties. But different to discretionary trust, there's fixed entitlements. So the unit holders, depending on how many units they hold, they have an actual fixed share, usually in unit trusts, work a little bit like shares in a company. The rights of the unit holders are dealt with by the deed. Is the trustee a company? Normally the shares should match the unit holders. If they don't, you can run into some unexpected problems, so it's worth looking at. Something that often is not covered is whether or not there's a unit holders agreement, which is surprising in these because you're dealing with unrelated third parties more often than not. So even if we have units in a unit trust owned by a number of discretionary trusts, for example, there should be a unit holders agreement that says what happens if there's a change of control with any of the unit holders, generally what happens as far as the unit holders and the trust management is concerned. So really important to think about those things in particular. Self-managed superannuation funds, I'll just go through these relatively quickly so we don't run out of time because I do want to touch on probate. But these are a growing area of dispute. Often a lot of problems in these where you need to think about where things are going. I've mentioned that case re Narramon mainly because that was a test case that was run a number of years ago in the Supreme Court in Queensland around death benefits in particular. And the court determined that was a financial decision, not a testamentary decision. What that means is that your enduring power of attorney can have an impact on death benefits and superannuation, and possibly also as far as withdrawing funds. So if you've got a self-managed superannuation fund, you really need to think about what your enduring power of attorney says in the context of how you're dealing with any superannuation funds. So who controls it? Be very careful about multiple members in a fund. Bringing children into a self-managed superannuation fund, how that's controlled, you need to look at your deed and be sure about exactly how things are going to work. What happens if there's land in superannuation? Do you have lease documents in place? You need to have arm's length arrangements. What does your trustee say? What does the constitution of your corporate trustee say? Who controls if members lose capacity? This is a case, relatively recent one, with very large assets in the fund. Fundamentally, the fund owned most of the property in this particular earth-moving business, and There were issues over time because one of the children was no longer in the business. That created a whole bunch of family problems. So we often see in family businesses, unfortunately, grandchildren getting used as weapons. That was a problem, created a whole range of issues. They decided essentially to sell the business to move on when mum was diagnosed with stage 4 brain cancer. Now, she still had capacity, but she started to do some very, very odd things. So there were capacity questions. She changed her enduring power of attorney. We had a bunch of issues with how the companies were structured, what the shareholding was in there, who controlled what. Not ideal when you are negotiating a major sale to a foreign entity. So understanding what's sitting in your structures, what's sitting in the fund, how they all interact can be very important. Companies, a lot of you will deal with private companies in particular. The main thing you need to understand from an estate planning perspective is how the shares are held, or is there a shareholders agreement that does something unusual? So keep that in mind when you're looking at companies in particular. So the documents in companies are important. Is your constitution up to date? I'm still occasionally seeing older memorandum and articles of association. That can create some real problems because in previous years, that didn't cater for sole directors, for example. So you need to really think about, is your constitution up to date? Mostly they will be, but there are still some old ones floating out there. Do you have a shareholders agreement? Who owns the shares? Are they different classes of shares? And if they are different classes of shares, do they have different voting rights? Can you find the share issue documents? So just being careful around the detail, particularly with the shareholding, is important. If the shares are owned by a trust, as we've talked about trust control, well, who actually controls the company? If it's 100% owned by trust, that would be probably the appointer. So you need to work through these things in structures. It's fairly important. If the shares are owned by individuals, if you want to transfer those shares at a later point in time, you're probably going to have a potentially significant capital gains tax problem. Otherwise, you need to think about, do you have a family provision problem if those shares are going into your estate? So thinking about all of that with companies. This was a medical company where the shares were owned personally. They had done a shareholders agreement that had succession provisions, basically those put and call options I talked about before, where there was insurance funding. One of them died while on holiday skydiving in Mexico. Suddenly, dentist Jim is in business with Wendy because they had done the shareholders agreements, but they'd never signed them. So you need to be, put them in place, but make sure you sign them. So we'll just get on now to capacity and enduring powers of attorney, because as I say, this is an issue that's arising quite a lot. You need to really think about your circumstances for the principal whose attorney document it is, your enduring document it is. So what are the assets? What are the circumstances? Should different people be appointed to control business entities as opposed to personal assets? Do we have different issues with someone might be more appropriate for financial power than personal and health power? Enduring documents aren't simple documents. You need to really carefully consider your overall plan, what your structures are, particularly in family business and agricultural business, and particularly if you have self-managed superannuation funds. What should be in there that should be dealt with if there's a loss of capacity? Really important to have them. You might need some significant detail around terms and what decisions can or can't be made by an attorney. And as I said before, reviewing that control of the structures. So with an enduring power of attorney, if you do not have one, please get one. These are incredibly important documents. It doesn't matter which state you're in, there will be a version to do for what happens in the event you can't make decisions for yourself. If you have one and you can't find it, you might as well not have one. So make sure you've got one and that you can find it. As I said, have you appointed the right people for the right decision-making power? How are they appointed? Are they appointed jointly by majority, severally? Issue for attorneys, if you're appointed, for example, by majority, if you don't agree with a decision made by the majority, you can still be liable for a breach of duty. So thinking through exactly how you're appointing people, who's appropriate to control what if there's a capacity event, and do they get on as well? Similar to executors if you're appointing them jointly. If they don't get on, you're probably going to have a tribunal making a decision about who can actually act, and it might not be who you want to have acting. Are you in business with any of them, or are you planning to transfer assets to them during lifetime? Now, I'll talk about this from a Queensland perspective, but there are similar provisions in most states, and this is quite important for primary production businesses and any family business, frankly. So this was one a few years ago, enduring power of attorney done by a regional firm. Dad went into aged care, wasn't that elderly, early stages of dementia, and did lose capacity, but it was quite possible he was going to live for another 10 years or so. Son still needed to run the partnership and needed to extend the overdraft. There was no conflict waiver in the enduring power of attorney, and the bank wouldn't deal with him. Because the problem with conflict provision is if you're in business with someone, so in this case, Son's in business with Dad, Son was saying, well, this is for Dad's benefit too, because it's also his asset, but it also benefited Son. And technically that's a conflict. So you need to think about that if you're in business with family members that you're appointing under enduring power of attorney. Are there situations where you need to actually consider where you have to waive a conflict to ensure that the business can still run if someone loses capacity? Sometimes you don't want to waive that conflict. It depends on who you're appointing, but you do need to think about it. One I am seeing crop up much, much more, very commonly from a dispute perspective, particularly after the relevant person has passed away, is the presumption of undue influence. So, again, Queensland legislation, but relevant provisions in most states. If a transaction occurs and it's between the principal and an attorney or a relative of the attorney or a business associate or close friend. So, for example, Dad transfers assets to Son, or Mum gives money to someone and they're actually a named attorney at the time, there is a presumption that that was undue influence. So I'm seeing a lot of people digging into transactions that occurred over previous years to see if they can be set aside on the basis there was undue influence. It's a rebuttable presumption, but you do need to have evidence to show that it can be rebutted. So if you are considering transferring things during lifetime, check your enduring power of attorney first. And just make sure that you're not creating a problem for the person you're transferring to, because they were named as an attorney in the document, which will crop up at a later point. So be wary about that. So in this particular case, John gives his property to his son, James, 5 years prior to his death. The son's named as an attorney in John's enduring power of attorney. It is not uncommon. There is no term in there acknowledging the gift or showing that there's been advice provided at the time it was made, or considering those issues. Do we have an undue influence problem? Someone's probably going to claim that there's been undue influence. And then the whole fairly significant amount of work needs to be done to actually rebut that presumption and show that the gift was valid. So just as I say, being conscious of that if you're transferring things during lifetime. So things to consider in enduring powers of attorney, who to appoint and how to appoint them. As I said before, some attorneys might be better for financial matters rather than personal matters. You need to think about, depending on which state you're in, might limit how flexible you can be with this, but you do need to think about exactly who you're appointing and why, and what powers you want them to have. Advanced health directives, this is specifically Queensland. There are other health directives in other states and territories. That's important to think about if you want specific medical treatment or you don't want specific medical treatment. So think about those. Next level up, we like to say have an enduring power of attorney, but worth thinking about, particularly if you've got strong views about that or you want to take pressure off a loved one having to make difficult decisions. So probate, which we'll end on, but important to think about from the context of administering estates. Essentially what probate is the Supreme Court formally recognising that last will as the legally valid last will and giving the executor authority to administer the estate. You apply for a grant of probate of the will. If there's no will and it's intestacy, you're applying for letters of administration. So issues with the grant of probate, if you have to have probate, there'll be filing fees, there'll be advertising fees. If it's a relatively small estate, that can be seen as an unnecessary expense because filing and advertising just as an outlay on its own is normally around $1,000. So thinking about that in the context of what you might need to do. The issue for probate, particularly in Queensland, is predominantly who's going to release the money without it. Now, banks generally will only release without probate for small amounts. So anything over $50,000 for some banks, others over $100,000, they will not release those funds without probate. Most aged care institutions, if they're going to release money, they will want probate before they release it. So probate, particularly in Queensland, but generally in a number of states, is mostly driven by third parties wanting to have protection of the court that it was the last valid will. So whether or not you need probate, well, generally for larger states you will, but in any event, it is mainly to authorise the Executive Act. And if you're dealing with the ATO, this has happened over the last 6 months or so, and your accountant needs to deal with the ATO normally won't talk to your accountant unless you've got probate now. So we're heading increasingly towards having it rather than not. But if you have an estate, for example, that's largely joint assets going with the survivor, it may not be necessary. But mostly probate, particularly in Queensland, is driven by third parties. So knowing what third parties own your assets might be important when you're thinking about the costs longer term. Very briefly, I'll look at intestacies is why you should have a will. There's a priority order. I won't run through it, but it's priority order about who can apply for letters of administration and getting to that point. And then in Queensland, for example, under the Succession Act, if you have an intestacy, surviving spouse, this isn't indexed. So these days it's a pretty low amount, 150,000 in household chattels, and then it's divided depending on how many children there are. There are different provisions for if there's no spouse and only children, if there's no children or spouses, if there's no next of kin, the government gets it. So thinking about these are one of the many reasons to have a will in place. If you don't, there'll be a particular legislative process and it may not go to who you intended it to go to. And finally, if you don't have an enduring power of attorney, just don't. Go and get an enduring power of attorney. The problem with no enduring power of attorney, someone will have to apply in Queensland, for example, it's the Queensland Civil Administration Tribunal. I'm sure a few of you have had to go through it for parents. Significant documentation to be completed. No guarantee the tribunal will appoint who someone would have wanted to have appointed. So if you don't have an enduring power of attorney, please put one in place sooner rather than later. Nuts and bolts of running through it very quickly, almost managed to finish on time. Any other questions, Beck, coming out of that?
No, I think you've bamboozled everyone, Kylie. I do have one question.
Try to clarify things rather than bamboozle.
Just on that final slide, the enduring power of attorney documents are publicly available, the forms online. Would you advise people to just go ahead and fill them out and then get them signed off by like a CDEC or a solicitor? Is that better than having nothing?
It's better than having nothing. It's certainly better to have one than to not have one. You do need to think about if your situation's a little more complex, as I talked about, those done yourself won't necessarily cover control of other things. So you just need to be a bit careful. If you're in a slightly more complex situation, you should have advice before one's put in place. But something is better than nothing when it comes to an enduring power of attorney.
Great. Thank you so much for clarifying that. All right, well, we have nearly managed to finish on time. Thank you so much to everybody for joining us. If you do have any further questions, you can, of course, contact Kylie directly. Her details are there, and as I said, we'll circulate the slides after this for anybody who wasn't able to join us. We did have to rush a bit of information through, so feel free to reach out if there's something that occurs to you that you think might be a problem. Fantastic. All right, well, we'll end it there. Thanks again for joining us, Kylie, and thanks to everybody else as well. Have a good day.